Hello, friends. It is an absolute pleasure to be with you here today in this gorgeous facility. So thank you so much to Judge Bigler and to everyone for having me here. It's my absolute pleasure to be here. So my task today is to talk to you a little bit about civil and regulatory jurisdiction and to speak about the lay of the land. Of course, as you know, because we've spoken about Carpenter versus Murphy and several of our other presentations, you know that there could be some impact to that, will likely be some impact to that based on the Supreme Court's decision. But we're going to talk about where the lay of the land is today and how civil and regulatory jurisdiction looks. So in terms of a presentation overview, we're going to start off, of course, with our definition of Indian country and look at how cases have interpreted that definition of Indian country. Then we're going to take a deeper dive into diminishment and disestablishment, which of course is at the core of the Carpenter versus Murphy case. And then we'll talk about civil jurisdiction. We'll talk about it generally and kind of where the presumption lies. And then we'll look at it in cases where you have non-Indians on non-Indian land and how that changes a little bit. So I have approximately, I'll speak for about 30 minutes, and then if you have any questions at the end, or if you have any questions as I'm talking along, please feel free to stop me. We're a relatively informal group, so feel free to stop me if any additional information would be helpful. Okay, so of course let's start with our definition of Indian country. You probably know that it's defined at 18 U.S.C. 1151, which of course is the criminal portion of the U.S. Code. However, the U.S. Supreme Court has said that that can be used in a civil context as well. So even though that is in the criminal portion of the code, we still do use this definition. And that includes all reservation lands, notwithstanding instances of patents and right-of-way, then dependent Indian communities, and allotments, which of course is going to impact us here in Oklahoma. So let's talk a little bit about how those various aspects of Indian country have been interpreted. So first we can take a look at another Oklahoma case, which you may be familiar with, Oklahoma Tax Commission versus Sac and Fox Nation, which was a decision from 1993. And here, of course, you probably remember and recall that numerous instances were occurring where the Oklahoma Tax Commission was attempting to apply various taxes to various nations here within Oklahoma, and this is one of those cases. And so the question is, what is the status of the reservation? And the court in the Oklahoma Tax Commission case said that Indian country is actually broader than just reservation lines. So up until the Supreme Court explicitly said it in this case, there was some question as to whether or not Indian country was the same as reservation or it was broader, so the court here says that it's broader. Also, this court reaffirmed that Worcester versus Georgia decision from the early 19th century, where the Supreme Court said that the laws of Georgia didn't have the impact on the Cherokee Nation. The court here says that there is a general presumption against state application of regulatory laws within Indian country. So the case is very helpful for that reason. So Indian country is more than just reservations, and moreover, we have this general presumption against the application of state law within the territory, which of course is at the heart of Carpenter versus Murphy, right? Because if the crime in that case did occur within Indian country, then the argument is, rightly so, that the state law would not have any force and effect. So the Oklahoma Tax Commission versus Sac and Fox Nation case is very helpful for that reason. Also, in terms of understanding what are dependent Indian communities, the court gave us this very helpful, although not necessarily good for Indian country, decision in Alaska versus Native Village of Venati Tribal Government, which was a decision from 1998. Interesting little side note, now Chief Justice Roberts at the time was in private practice, and he represented the state of Alaska in this case. So some commentators were a little concerned about where he stood on Indian issues because he had represented the state of Alaska against the Native Village in this case. But at issue here was whether or not Indian country continued to exist within Alaska, because as you know, Alaska has a different legal scheme that applies there. They have the Alaska Native Claims Settlement Act, and there was some ambiguous language in that act as to whether or not Indian country still persisted after its passage. So ultimately, what the court determined in that case was that there was only one reservation in Alaska on Mekaleka Island. And then more importantly, the decision gives us this test for determining when we have dependent Indian communities. And that test is where the land's been set aside by the federal government for the use and enjoyment of Indians, and where the federal government still exercises superintendence. So if we don't have an allotment and we don't have a reservation, but we do have land that's been set aside for Indians and still under federal superintendence, then we still do have Indian country because we have a dependent Indian community. So that decision gave us the definition of what is a dependent Indian community, so that's helpful as well. Then we can turn to this question of diminishment and disestablishment. And again, this is really at the heart of our Carpenter versus Murphy case. But before we get into talking a little bit more about Carpenter, and I know you talked about it already, let's talk about the three-part test. So the Supreme Court established the test for when we have diminishment or disestablishment of Indian country under Solomon versus Bartlett, which is a decision from 1984. And interestingly, we'll talk about the Nebraska versus Carpenter case in one second, or excuse me, Nebraska versus Parker case in 1 second, 2016. But one important thing is that in 2016, the Supreme Court applied the Solomon versus Bartlett test. So as recently as 2016, the Supreme Court has said we continue to use the Solomon versus Bartlett test. So that's going to be one of the interesting things about Carpenter versus Murphy is to see, does the court in 2019, only 3 years after Nebraska versus Parker, continue to say we continue to use Solomon versus Bartlett? And of course, those who argue the case and those of us working in Indian country very much hope that the answer is yes. But the reason why it's important to mention the Solomon versus Bartlett test, again, this is the three-factor test that the Supreme Court developed to determine where there's diminishment and disestablishment, is that it gives us the definition so that we can apply that. And we can apply that in any case where it may be relevant. So the first and most important factor, and that's another thing about the Solomon test, not all of these factors are to be equally weighted. So the court said very clearly in Solomon versus Bartlett, and then again in 2016 in Nebraska versus Parker, that the first test, or the first factor, is the most important. And so the first factor in the Solomon versus Bartlett test is what is the statutory language. So we look at the language to see what does the either statute or treaty actually say with regard to diminishment or disestablishment. And the court's been very clear that you need to have explicit references to diminishment or disestablishment. This means that you need to have language of cessation, language that says that the tribe or the nation actually agreed to the diminishment or disestablishment. The court has repeatedly, and lower court federal courts have repeatedly said that statutes that merely say that Indian lands are now open for settlement by non-Indians or open for sale is not enough to meet that language of cessation. Because having lands open for sale is not necessarily mutually exclusive of cessation. So therefore the court has been, again, as recently as 2016 in Nebraska versus Parker, has been very consistent in saying you have to have explicit language. So step one under Solomon is you look for that explicit language either in the statute at issue or the treaty at issue. Then step two is you look at the actual treatment at the time. So what did Congress think it was doing? What did local governments think it was doing? And this can be really helpful when you look at the legislative history, because if you have ambiguous language, looking to that legislative history, if there's clear indication that Congress thought it was doing X, that Congress thought it was diminishing or disestablishing a reservation, then that can be an indication of diminishment or disestablishment. But again, the court says we give preference to the actual statutory or treaty language at issue. Last and least is the third factor, and the federal courts have consistently said that this third factor is to give the lowest amount of weight, so it is not balanced equally with the first and the second factor. But the third factor is this question of what is the demographic information, what is the subsequent history. So it is relevant if you have a territory that's become overwhelmingly non-Indian since the act or the treaty occurred, but that is not necessarily in and of itself indication of diminishment or disestablishment. So we do look at that subsequent history, we do look at demographic data, but the Supreme Court and lower federal courts have been very clear that the third factor is to have the lowest weight. So in other words, if you have only subsequent demographic data that suggests it's now a non-Indian character, that's not enough to show diminishment and disestablishment. disestablishment. Now, of course, when you talk about Carpenter versus Murphy, you know that this was Oklahoma's big argument there, right? That we have Tulsa now within the territory. It overwhelmingly has this non-Indian character, and so therefore that suggests diminishment or disestablishment. But if the court is to follow its past practice, that would be given the lowest weight. It's not to say that it doesn't give any weight in the court's analysis, but the court has been pretty clear since the solemn test was developed in 1984 that that's to get the lowest amount of weight. So again, it's going to be very interesting to see what the Supreme Court does in Carpenter. Then fast forward to Nebraska versus Parker. Again, a case from 2016, so really interesting case. One thing that's interesting about this case is it was authored, the majority opinion was authored by Justice Clarence Thomas. Now, generally, we don't think of Justice Thomas as being a great friend to Indian country, but what do we associate Justice Thomas with? He's a strict interpretation guy, right? He likes statutory text. And what is the first factor of the Solemn versus Bartlett test? It's essentially a strict statutory construction test. And so it is interesting that Justice Thomas wrote this opinion, but it is consistent with his general reliance on the actual text. And so basically, he reaffirms in Nebraska versus Parker that the solemn test remains the test for whether we have diminishment or disestablishment. So what's going on in this Nebraska versus Parker case, we have a situation where Pender, Nebraska, the founder of Pender, Nebraska, had purchased a piece of land within the Omaha tribe's territory and had subsequently founded Pender, Nebraska. So this small, relatively small village within this, the Omaha tribe's territory. And the Omaha tribe was trying to enforce regulatory authority there. And so the village, Pender, was saying, well, we're no longer part of the Omaha tribe because this has been diminished and disestablished because our founder was able to purchase this land when Congress enacted a statute that said the land was now available for purchase. However, the Supreme Court disagreed with that. And the Supreme Court said, okay, step one of solemn. We look to the actual language. And yes, the language at issue in Nebraska versus Parker, again, opened up the territory and allowed for land to be purchased. However, nowhere in that statute did Congress specifically say, and we cede, or that there's cessation, or that the Omaha tribe's territory ceases to exist. And so therefore, merely opening up the land for purchase is not that cessation language that we need to find diminishment or disestablishment under the first solemn factor. So on the basis of the statutory language, Justice Thomas says, nope, there's no clear statutory language here that suggests diminishment or disestablishment. Moreover, the court says in Nebraska versus Parker a couple of important things, especially in terms of Carpenter. It says that there's a presumption against diminishment and disestablishment. So again, Oklahoma's going to have to overcome that in the Carpenter case, so we presume against. Also, we have to look for very specific and explicit language from Congress in order to meet that first solemn factor. Again, that's consistent with the presumption against diminishment or disestablishment. Now, in Nebraska versus Parker, Nebraska argues, well, the village of Pender is overwhelmingly non-native. That argument probably sounds familiar, right? It's the argument that's being made in the Carpenter case. Tulsa is overwhelmingly non-native, and so the demographics suggest that there's been diminishment or disestablishment. However, in the Parker case, Justice Thomas pretty clearly rejects that argument and says, no, there's no statutory language to suggest that. The legislative history at the time that the statute was passed is at best ambiguous. You can make arguments other ways. So in many instances, as you know, because we've talked about Carpenter versus Murphy already today, this case sounds a lot like Carpenter versus Murphy, right? In terms of you have ambiguous statutory treaty language, you have mixed legislative history for the time. It's not clear if Congress knew what it intended, and then the demographic data does suggest that the area is non-native in character. However, again, that third factor is to have the lowest weight. So, a lot of commentators have looked to Nebraska versus Parker and said, well, Supreme Court, did you mean what you say and mean what you said? Because if you did, then Carpenter versus Murphy should be decided in favor of Muscogee Creek Nation. However, a couple little caveats to that. The first is at the end of Nebraska versus Parker, Justice Thomas says that we specifically decline to address the issue of acquiescence or the doctrine of latches, because none of the parties in Nebraska versus Parker raised those arguments in front of the court. Now, of course, that's not the case in Carpenter versus Murphy, where we have seen those types of equity arguments being raised. So that is one difference between the two cases. Those arguments of acquiescence, i.e. that the tribe acquiesced to the non-Indian presence, or the doctrine of latches. The doctrine of latches is this argument in equity that we saw in the City of Sherrill case, where the Supreme Court found that even though the nation there may have had a viable legal argument, that it ultimately had just been too long for the nation to raise that argument. Those arguments were not before the court in Nebraska versus Parker, and they are before the court in Carpenter versus Murphy. So even though these two cases legally look very similar, that could be a basis upon which the Supreme Court distinguishes the two cases. Of course, we'll just have to wait and see. Now, I'm not going to spend too much time on Carpenter versus Murphy because, again, I presume that this horse, the proverbial horse, has been beaten to death, as you've already had an entire speaker discuss it. But we can look at the 10th Circuit decision, of course, is very promising. And very promising in terms that it pretty clearly upholds Solomon versus Bartlett and says that if we apply that three-factor test that we applied, then this is a situation where the Muscogee Creek Nation has not been diminished and disestablished. There's no specific reference to cessation in the relevant statutory language at issue, and diminishment and disestablishment is not to be lightly affirmed, right? Affirming what we saw in Nebraska versus Parker, we have to have that explicit language. And again, in the Carpenter versus Murphy case, the case of Tulsa, yes, Tulsa does have this non-Indian characteristic, but as we know from Nebraska versus Parker, that third factor of Solomon versus Bartlett is the least relevant factor, and so therefore, even though there is a non-Indian character, that's ultimately not going to win the day. So it's going to be very interesting to see what the Supreme Court does in Carpenter versus Murphy. Is it going to say, we said what we mean and we meant what we said in Nebraska versus Carpenter, and so therefore find in favor of the Muscogee Creek Nation? Or is the Supreme Court maybe going to go down this line of acquiescence and doctrine of latches and say, well, in this case, it's just been too long to find jurisdiction for the nation, or perhaps because Tulsa is obviously a bigger city than Pender, Nebraska, perhaps the court will say, well, Tulsa's just too big to allow for native jurisdiction. But of course, as you know, other large cities are within the territories of tribes. So a great example of that is Tacoma, Washington, within tribal territories. So it's not unheard of to have large cities within tribal territories. So this is definitely a case to watch. We don't have a decision yet, but we will have a decision by the end of June. So I assume everybody in this room is going to be waiting with bated breath for that decision. The other thing that's interesting about Carpenter versus Murphy, and I assume your other speakers mentioned this, is that the case was argued in November 27th, but the court asked for supplemental briefing on two issues in December of 2018, which is highly unusual. So it does suggest that the court may be split on this issue, and of course Justice Gorsuch has recused himself in this case because the previous decision was from the 10th Circuit when he was there. So it could get a 4-4 split, we just don't know. But it is highly unusual for the court to ask for supplemental briefing, and it did do so in this case. So definitely a case to watch. So now that we've talked about diminishment versus disestablishment and what is Indian country, we can talk about civil jurisdiction generally. And in general, the federal courts have somewhat conflated civil jurisdiction with civil regulatory jurisdiction. And that's the Strait versus A1 Contractors case, where the U.S. Supreme Court said that adjudicatory jurisdiction does not go any further than regulatory jurisdiction. And so as a result, when we're talking about the two, we have a tendency to see intertwining of both regulatory jurisdiction and civil jurisdiction generally. So up on the slide here, you have some basic primers for who has jurisdiction where. So tribes generally exercise exclusive jurisdiction where the matter occurs within Indian country borders, and both the plaintiff and the defendant are Indian. Where the matter occurs within Indian country and the defendant is a member of the tribe. And then there could be concurrent jurisdiction where you have different configurations of those two factors. But obviously both the place of where something occurred and then who is plaintiff and who is defendant is ultimately going to impact who has jurisdiction in that particular instance. So let's look a little bit more closely. And you have all of this in your handout that's provided, I think it's available online. So all of that is in the handout. And so if you're writing it down or want to have it in your back pocket, please go ahead and take a look at that handout. But in terms of when tribes have jurisdiction, civil jurisdiction, we can first look at the Williams versus Lee case from 1959. That was a case involving a business on the Navajo Reservation, and so the incident occurred on the reservation, and the defendant was the Navajo business and a Navajo tribal member. So again, it goes back to one of those presumptions because we have an incident that occurs within Indian country and involves an Indian defendant. So in that case, the court said, again, in 1959, that the tribe has jurisdiction where the matter occurs in Indian country, here is what it was within the reservation, and you had an Indian defendant. So the court said that the Navajo Nation in that case had jurisdiction. Then we really get an affirmation of that in Fisher versus District Court from 1976, where the court said that the tribe has jurisdiction over Indian plaintiffs and defendants when the matter occurs in Indian country. So again, an affirmation of that fact, that where at least the defendant is Indian and the matter has occurred in Indian country, the tribe's going to have jurisdiction. Now, I put but CF, right? So but compare to Nevada versus Hicks. So Nevada versus Hicks is a decision that we got in 2001. And I remember at the time, I was a young lawyer, and I thought, oh, surely this is going to be a win for the tribe because of this past precedent, Williams versus Lee and the Fisher case. Because what happened in Nevada versus Hicks is it happened within the reservation. It involved the property of a tribal member, and basically Nevada game wardens believed this tribal member to be poaching endangered species. So they came into his home not once but twice and ransacked the home looking for evidence that he had been poaching endangered species. So again, as a young lawyer, not knowing better, I thought, oh, this is an Indian, this occurred at an Indian's property within the tribal nation. Tribes can have jurisdiction over this. Nevada can't have come in without going through tribal court and getting a warrant through tribal court. Well, the Supreme Court disagreed, and that's why I have a but CF here to the Fisher case, and said that really, and this was a case authored by Justice Scalia, so that really, when you have two sovereign interests, so here you had the tribe's interest in its citizen and in the citizen's property and was on the territory of the citizen, and you have the state's interest. So he said, Nevada has this legitimate interest in making sure that people are not poaching endangered species, that we have to balance those two interests. So for the first time, Justice Scalia kind of introduces this idea of balancing. And so in this case, because the interest of the tribe was relatively low, yes, this individual citizen's property was damaged, but the tribe's interest in its ability to self-govern was not really impacted by this. And conversely, Nevada's interest is pretty high because Nevada has this interest in protecting endangered species. If we balance that, it was okay what Nevada did because it had the higher sovereign interest. And then you get some concurrent opinions as to what role does the land play, because again, going into this as a young lawyer, I thought this is going to be a win for the tribe because it occurred within Indian country. And so then there's this discussion back and forth between Justice Scalia and Justice O'Connor as to what status land plays. So we do know that where another sovereign is involved, such as the federal government or the state, that analysis could look different. And so that's why I put the but CF there. But otherwise, in general, if something occurs within Indian country and involves an Indian defendant, then we're going to have tribal civil jurisdiction in that case. Now, I told you that civil jurisdiction and civil regulatory jurisdiction really become entwined. And the case that does the trick of entangling those two is Montana versus United States from 1981. And what's going on in Montana versus United States, you may recall this case where the Crow Nation is attempting to regulate fishing within its territory. For those of you who've been up to Montana, you know that a beautiful blue ribbon trout stream goes through the Crow Nation. River runs through it, right? It was filmed in Montana. This is a place where people love to go fishing. And so obviously the Crow Nation wants to regulate that and have some control over fishing within its territory. But this is fishing that's occurring on non-Indian land within the reservation. So it's non-Indians engaging in this otherwise prohibited activity on non-Indian land. So it's really important that when you're talking about Montana versus the United States, you remember the status of the land and the parties in that case. So those are non-Indians and non-Indian land within the reservation. And so in that instance of non-Indians on non-Indian land within the reservation, the Supreme Court says that the general presumption is that tribes do not have regulatory authority over individuals in that situation unless one of two exceptions apply. So the first exception is a consensual relationship. So if I agree to the tribal court's jurisdiction, then of course the tribe can have jurisdiction over me. And there's been a lot of cases in the lower federal courts, one in the Supreme Court, about what you have to actually say or do to have consented. But if I have a consensual relationship with you, then absolutely the tribe can assert jurisdiction over me. But the second exception, Montana exception, is where we tend to spend a little bit more time. And that's what many commentators call the direct effects test. Basically, if that non-Indian's activity has a direct effect on the economic security, the health, welfare of the tribe itself, then the tribe has the ability to regulate non-Indians, even on non-Indian land within the reservation. So that's the Montana test. General presumption against regulatory jurisdiction, where you have non-Indians on non-Indian land, unless one of those two exceptions apply. And then subsequent U.S. Supreme Court cases told us, gave us a little bit more definition of what that second exception means, and said that when we talk about a direct threat, it really has to be a direct threat against the ability of the nation to govern itself. So is this directly impacting the nation's ability to govern? Another case that's helpful for us to understand where tribes have civil regulatory jurisdiction or civil jurisdiction is again that Strait versus A1 contractors decision, which came after the Montana decision, where it was a case involving a highway collision. So not an instance where the tribe was trying to regulate anyone, but the tribe was asserting adjudicatory jurisdiction because the collision occurred within the tribe's territory. And so the question was whether or not the tribe had the ability to adjudicate that matter. And the court ultimately, the Supreme Court said, ultimately no, because the civil regulatory jurisdiction of a tribe does not exceed its regulatory jurisdiction. So in other words, a tribe can't adjudicate a matter that it wouldn't have regulatory jurisdiction over. So that's where we get the entanglement. So oftentimes when we're sitting as tribal court judges, we have to first ask ourselves the question of, would the tribe have the ability to regulate this individual? Because if yes, then I can adjudicate the matter, but if no, then under Strait versus A1 contractors, I cannot adjudicate the matter because I cannot assert adjudication beyond my civil regulatory authority. Last thing that I'll mention, and then again, I'll open up for questions if anybody has any questions, is just that when we're dealing with matters in Indian country, and most of you probably know this, you must exhaust your tribal remedies. And so the Supreme Court has said this on several instances. A good example of that is National Farmers Union Insurance Company versus Crow Tribe, where the Supreme Court said that federal court should not become involved in a matter until the tribal court has had an opportunity to make a decision as to whether or not it has jurisdiction. A couple of reasons for this. This is, of course, because of concerns about efficiency, but also those of us who serve as either attorneys working in tribal courts or as tribal court judges more likely are subject matter experts and probably understand this, quite frankly, a little bit better than our federal colleagues. And so let's go ahead and let the tribal courts take a first stab at whether or not they have jurisdiction before the federal courts intercede. There's a couple exceptions to that where there's either clear nefarious activity going on, right? So a claim hasn't been brought in good faith, or if the tribe clearly doesn't have jurisdiction, then on very rare occasions, federal courts have allowed for exceptions. But otherwise, in general, you do have to go to tribal court first. All right, so with that, Chamber Gwitch, That's what I have, and I'm happy to answer any questions that anyone may have. Perfectly clear. All right, well, you have my contact information. If anything does come up, I'm always happy to answer questions. Otherwise, again, thank you for having me today. And, yes, Judge Hager.
No, I do have one question. Do you have new contact information?
Yeah, so I think my new email address is Elizabeth.Kronk.Warner. They had to get all my names in there, it's really long. Which is warner@law.utah.edu. So that very long, elizabeth.kronk.warner@law.utah.edu. Well, thank you so much. Enjoy the rest of your conference.